It is for me a great honor and distinction to introduce Professor Frederick Schauer, although I deem my role here is somewhat redundant because Professor Schauer is very well known for most of us as to need any introduction at all. This is a matter of course in what concerns English-speaking legal culture and is becoming more and more true in other countries like Spain, Italy, etc. He's been professor at the University of Harvard, the University of Michigan, and Chicago, and visiting professor in many others, and is now David and Mary Harrison Distinguished Professor of Law at the University of Virginia, Fellow of the American Academy of Arts and Sciences. His books are of a paramount importance to face the present problems of legal theory. Leaving aside his important works on freedom of speech, in this Congress, his books on legal argumentation are to be underlined. Playing by the rules, a philosophical examination of rule-based decision-making in law and in life, with many editions and translations into Spanish in the collection of Marcial Pons that organizes this Congress. This book was a sort of focus of light in a dark age of predominant Dworkinian persuasion. In the same line, Profiles, Probabilities, and Stereotypes insisted in the importance and unavoidability of generality in practical reason. It was a book against particularism as a presumed better way of getting our practical conclusions. It goes without saying that this is a decisive move for legal theorists and most of all for legal practitioners. In the same vein, his last book, Thinking as a Lawyer, A New Introduction to Legal Reasoning, shows with great accuracy and insight that, and I quote from the introduction, the special oddness of legal reasoning is that every one of the dominant characteristics of legal reasoning and legal argument can be seen as a route toward reaching a decision other than the best, all things considered, decision for the matter at hand. Rules, generality, and institutional final points in the process of decisions are all, in my opinion, the framework of Professor Schauer's thought, and are as well the basic basement for me to understand the noble ideal of the rule of law. It is a great honor and a great pleasure for me to give him the parole, to give him the floor, and to thank him for being with us here this morning. Thank you.
Thank you, and thank you to Professor Laporta for an excessively generous introduction. Thanks as well to Marcial Pons Publishers for sponsoring this remarkable event, to Jordi Ferrer and his colleagues for organizing it and conceiving it, to to the University of Girona faculty, all of whom and others have produced a quite remarkable event. We would never see anything like this in North America. A Congress on the philosophy of law in North America would likely take place in a small seminar room or in the American slang in a telephone booth back when there were telephone booths. That so many of you have come for this is remarkably gratifying. Before I start, let me just apologize in advance that I will not be able to enjoy the full 3 days of this event. Due to a death in the family, I will be leaving later today, and that is my loss. I hope to meet many of you in the course of the day that I have not met already. So we are here to discuss jurisprudential methodology. And that is a topic that usefully can be divided into two questions. One is the question about what we study, and the other is the question about how we study what we study. So the what and the how, it seems to me, are two different questions. I am concerned primarily with the first, primarily with the what, and not very much, at least here, with the how. That is, I am concerned with the scope of jurisprudence. I am concerned with what is a proper topic for jurisprudential inquiry. And in some respects, I am concerned, therefore, with the question, what is jurisprudence? But in saying that I am concerned with the question, what is jurisprudence, I should make clear that I am not concerned with the word jurisprudence. I am not concerned with defining the word jurisprudence. I am concerned rather about the definition of a field, the definition of an area of inquiry. The philosopher Simon Blackburn has observed that many methodological debates are typically political bids for ascendancy within a discipline. And although I don't see what I am saying as necessarily political in Blackburn's sense or in any other sense, I do think that the topic of the scope of jurisprudence is a topic, as Blackburn suggests, that relates to what shall be included and what shall be excluded from the idea of jurisprudence and from all of the sociological emanations of this or that field. More specifically, I am concerned with the question, at least in this paper and today, with the question of whether the non-necessary but statistically predominant features of law are matters of jurisprudential interest. Not just whether they are matters of interest, or whether they are matters of sociological interest or matters of journalistic interest, but rather whether the non-necessary but statistically predominant features of law are things that can be studied and should be studied with jurisprudential methods and can and should be understood as part of the field of jurisprudence. In raising this question, I seek to challenge at least one part of what I take to be a common view. The common view has two parts, and I only want to challenge one of them while accepting the other. The first part of this common view is that an important jurisprudential task is conceptual analysis of the concept of law itself. Analysis seeking to explain the nature of law by identifying its essential or necessary features, the properties without which something would not be law. The second part of the common view is that the task that I have just described as important is not only important, but is the only important important task of jurisprudence properly understood. That task, the conceptual analysis of the concept of law and the search for the essential or necessary features of the concept of law, defines the field of jurisprudence. Other inquiries might be interesting or important under this view, but they are best designated, as Joseph Raz designates them, as sociological rather than jurisprudential. The common view is articulated with particular clarity by Raz. Julie Dixon has also expressed it, and there are stray phrases or quotations from the works of Kenneth Hima, Jules Coleman, and others that might be understood to be consistent with that. As I have mentioned a few minutes ago, it is not my intention in this paper, or in fact generally, to challenge the first part of this common view. For purposes of this paper, I accept that there are concepts. I accept that the analysis of concepts is possible and that it is valuable. I accept that the analysis of concepts can be undertaken with non-empirical, or at least with non-social scientific philosophical tools. Moreover, I accept that law is such a concept. Law is a concept that can be evaluated in a philosophical way, and that its analysis is important and valuable. And moreover, that I accept that the concept of law can be philosophically analyzed without taking on or making moral or political commitments. Some have described this as descriptive, but as Coleman and others have observed, the term is slightly misleading, maybe more than slightly misleading, because there may very well be normative commitments that are involved in undertaking such an analysis. The important question, as we've just heard in the previous session, is at least in part the debate about whether those commitments must be, are necessarily moral or political. I accept that a loosely put descriptive analysis of the concept of law is possible. It is not only this last assumption that's controversial. Virtually every one of my assumptions that I have just mentioned is controversial, has been the subject of books and articles in their own right, but that is not my topic here. So with this groundwork having been laid, we can turn to the central issue. I want to argue that the nature of some phenomena, and in particular the nature of the phenomenon of law, can be jurisprudentially illuminated and explained by locating and analyzing those features which are probabilistically concentrated in law, even if they are not essential to it. In important work, both Joseph Raz and Julie Dixon have pointed out correctly, in my view, that in looking for the essential or necessary features of the concept of law, it is, as a practical matter, important, maybe I shouldn't use the word important here, vital or valuable to try to identify those features that are, they say, not only necessary, but necessary and important. One way of understanding what I want to argue this morning is as arguing that there may be things about law that are important but not necessary, that nevertheless can constitute a valuable component of jurisprudential inquiry with jurisprudential methods. In order to advance this argument, I want to take a break from law for a few minutes and talk about birds. There are two essential features of birds, or, if you prefer, two essential features of the concept of bird. One is the presence of a backbone. Birds are vertebrates. If something is not a vertebrate, it is not a bird. The other is the presence of feathers. Not fur, not hair, not scales, not a shell, but feathers. Birds, therefore, are feathered vertebrates. Both feathers and backbone are the necessary properties of being a bird, or the concept of a bird. Now note, as some of you may already be thinking, that I have said nothing whatsoever about flying. And that is because flying is not a necessary property of being a bird. There are vertebrates that fly but are not birds. Most prominently, or perhaps exclusively, bats. Bats fly but are not birds. There are some number of other animals, flying squirrels, flying fish, and flying squid, for example, that actually are gliders rather than flyers. But it is certainly not my purpose at this conference, in this talk, to analyze the concept of flying. So for the moment, take my word for the fact that bats, and only bats, are flying non-birds, or at least the only vertebrates that fly and are not birds. As well, as we know, there are birds that do not fly. Ostriches, penguins, emus, and some number of others are non-flying birds. So as a result, we can conclude that flying is neither necessary nor sufficient for birdness, and that for our purposes, and indeed among biologists, is relatively controversial. But although flying is not essential for birdness, it is hardly irrelevant that birds as a category tend to fly. Flying is not necessary for birdness, but flying is nevertheless an important feature of the category of birds. We understand and can learn a great deal about birds and about flying by seeing that and seeing why most birds fly and most non-bird vertebrates do not. So although flying is not essential to birdness, flying is statistically concentrated in birds in ways that I've just discussed. It is categorially concentrated in birds. And by being categorially concentrated in birds, it is arguably an important feature of the category of birds. It is an important feature of the bird population. Now, this is, of course, not just about birds. If you will indulge me one other example, let me talk for a moment about the Maasai and Mandinka people in Africa. As many of you probably know, the women of the Maasai and the Mandinka tend to average almost 2 meters in height. The men of the Maasai and the Mandinka are on average over 2 meters in height. But this extreme degree of height is not essential or necessary to being either a Maasai or a Mandinka. There are short Maasai and Mandinka, just as there are very, very tall Norwegians and other non-Maasai and non-Mandinka. But although great height is therefore not necessary for being a Mandinka, although great height is not definitional of these peoples, it is nevertheless an important feature of them. It is part of how we understand them as a group, part of how we understand them as a category. And therefore, so too with law. Insofar as what I have just suggested is right about some categories, insofar as the suggestion that there may be important features whose importance exists in their statistical concentration within a category, so too may there be important features of law that occupy the same kind of situation. Perhaps the best example of this, and I stress and will stress again that it is only an example, is the concept or the idea or the feature of coercion or the feature of sanctions. It is, as is now well known to this group, and now well known in the jurisprudential community, accepted that coercion is not a necessary property of the concept of law. Austin may have thought to the contrary, but whatever different people might think about Hart's attack on Austin, Hart's challenge to Austin in this regard is widely taken as sound and is taken as sound and is one that I take as sound. Coercion is not an essential feature of law. There are or at least can be non-coercive legal systems, just as there can be coercive systems that are not law. And in that respect, coercion, properly understood, is not one of the necessary or essential aspects of the concept of law. Nevertheless, it is surely of some interest, and not just of sociological interest, and not just of journalistic interest, that all real legal systems, or at least virtually all real legal systems, rely heavily on coercion and rely heavily on sanctions. The idea of coercion, moreover, as we know from important works about the topic by philosophers such as Alan Wertheimer and others, can be usefully illuminated using philosophical tools and philosophical methods. And therefore, understanding why it is that coercion happens to be so statistically concentrated in the category of law, even if not necessary to it, could be and ought to be a topic of considerable philosophical and jurisprudential interest. I stress again, however, that coercion or sanctions, I mean largely the same thing here, is just an example. I'll add another example in a few minutes. People may want to challenge this example. In other writings, some of which quite recent, I have, from a different perspective, tried to explain why I think that the inattention to coercion may be unfair to jurisprudential inquiry and unfair to some of Austin's valuable insights. But that's not inconsistent with accepting that coercion is not a necessary property of the concept of law. But as I said, this is just an example of a larger point. Moreover, it is a larger point about the way we think and about the way we talk in general. We can make sense out of the claim, German wine is sweet, even as we understand that not all German wine is sweet. But nevertheless, the category of German wine is a category that is sweeter as a category than the category, say, of French wine or Italian wine. It is, and is therefore a sensible locution once we understand the way in which making claims as non-necessary generalizations is a common part of ordinary talk. We say that Sweden is cold. We say that Yugos and Trabants are bad cars. We say that Ellsworth Kelly is a non-representational artist. And we use examples like this all the time to stress, and I use them to stress the importance of these statistical but non-universal generalizations in our conceptual apparatus and in our common thought. An important part of this conceptual apparatus is the use of these statistically dominant but non-universal characteristics. Now, to return to where I started in this talk, my claim, to repeat, is not that there is anything jurisprudentially wrong, jurisprudentially inappropriate, jurisprudentially mistaken, or jurisprudentially misguided about a philosophical search for the necessary properties of law. My claim is only that that search, valuable and important as it may be, does not exhaust the domain of jurisprudential inquiry. My objection is not to conceptual analysis. My objection is to its hegemony. It is one thing to say that, for example, Austin, Dworkin, and Fuller, for example, are wrong. It is another thing to say that they are simply not doing jurisprudence at all. And even though I agree with many of the criticisms of people like these and others, I want to resist the notion that Dworkin, by doing particular rather than general jurisprudence, is in some way doing something less central or less important to jurisprudential inquiry. And one can make that claim even if one believes that his substantive claims or his substantive arguments are in fact mistaken. Or, to give another example of what interests me here and elsewhere, consider the idea of precedent. Precedent is not a necessary feature of the concept of law. Indeed, it is not a universal feature of all existing legal systems. Indeed, it is historically substantially more important in common law legal systems than in civil law, although the well-documented phenomenon of convergence between common law and civil law has served to make precedents more important in civil law domains than it may have been in the past, or it may have been to some of the classic theorists of the civil law. But although precedent varies, and although most importantly precedent is not a necessary feature of law or the concept of law, it is something that is an important part of many legal systems, and perhaps even more than coercion, it is something that can be particularly valuably illuminated by philosophical analysis. Indeed, it is of some irony or some interest here that Joseph Raz, perhaps most prominent in describing inquiries other than inquiries into the essential features of law as sociological, has provided for us in important pages in The Authority of Law a very valuable and enduring philosophical analysis of the non-essential concept of precedent. Many others have analyzed precedent as well, using almost exclusively philosophical and analytic tools. The notion that this is in some way not jurisprudence or more marginal to jurisprudence or particular jurisprudence, if we understand, as many people do, particular jurisprudence as a label that is slightly pejorative, strikes me as unfortunate and mistaken. Now, one possible objection to much of this is the notion that in order to engage in the kinds of inquiries that I am suggesting about, for example, the non-necessary idea of precedent or the non-necessary idea of coercion, we nevertheless must engage in conceptual analysis about what is necessary for law as the prerequisite to this in order that we can know what we are talking about. There are a number of responses to that objection, but two strike me as at least worth noting. One, I have considerable sympathy with the view first and perhaps most prominently articulated by Roger Scheiner several decades ago, and more recently echoed by Brian Leiter in some of his work, that the concept of law necessary to engage in various other jurisprudential inquiries can be a somewhat thinner or shallower or common sense or ordinary person's concept of law rather than a fully worked out concept of law with all of its necessary features fully analyzed. More importantly, at least for me, even if it is the case that conceptual analysis, as it is now practiced with distinction among many people in this room, and some not in this room, even if that is a necessary condition for other forms of jurisprudential analysis, it is not necessarily the case that everything that is a necessary condition for further analysis is, by virtue of being a necessary condition, more important or more academically prior just because it is logically prior. There are numerous, for example, scientific disciplines or numerous inquiries about science presuppose the existence of the physical world, presuppose at least some form of rejection of radical constructionism about the existence of a physical world. Nevertheless, although the rejection of radical deconstructionism or radical relativism or radical social constructionism about the physical world is necessary in order to engage into an inquiry about gravity, for example, or any other inquiry in physics or chemistry or anything else, it would be mistaken to assume that just because of that, the inquiries about or the disputes about the existence of the physical world are more important or in some way more central than inquiries about the substance of physics or the substance of chemistry or the like. As a result of this, I want to conclude, perhaps making up a few minutes so we can still have the full time for our discussion period, but perhaps more importantly, the full time for our lunch. So I'd want to conclude by once again agreeing with the notion that the question, what is law, is important. But so too is the question, what is law like? My only claim on this occasion is that there is room for both of these questions, what is law and what is law like, within the province of jurisprudence. Thank you.
Professor Coleman asked.
Fred, that was very interesting. I forgot to say that for the first paper before my comment, so I wanted to make sure I said it this time. But Fred, I'm a little puzzled, right, by this paper. Not the claim, but that it's a claim against anybody. I have no difficulty in understanding why you would advance the view that you do. But my puzzle is why you think anybody else advances a sympathetically characterized version of anybody else, advances a contrary view. So, for example, it doesn't even have to be a predominantly interesting feature of law in order for it to be of jurisprudential importance. So let's take something that may in fact not be a predominant feature of law, but not a necessary one, namely that it in fact gives rise to reasons for acting. So you want to distinguish, take Raz's view, that law necessarily claims to give rise to reasons for acting. That has a certain significance in jurisprudence that the claim that law gives rise to reasons for acting does not have. But that doesn't mean that the claim that law gives rise to reasons for acting is not of jurisprudential interest. In fact, it is, since it's something which, on occasion, we believe law is capable of doing, and any jurisprudential view must have the resources in it to explain how that's possible. Namely, not just that it give rise to reasons for acting, but that it give rise to reasons for acting in virtue of characteristics of it which are essential to it. That is, distinctive of it and essential to it. But though this is not a feature of it that is essential to it, namely that it give rise to reasons for acting. So the right way to think about it seems to me to be this. The claim about the necessary features of law are claims about the metaphysics of law, and those claims are important with regard to what's important about the metaphysics of law, but not what things which are important to law, jurisprudence more generally. So, for example, suppose someone like Raz or myself or others have the view that the proper semantics of law is that we should interpret legal utterances as utterances about what we have moral reason to do or moral obligations to do. The metaphysics is interesting because we want to know whether the metaphysics can support that semantics. So we're interested in the metaphysics because we're interested in its relationship to the semantics. We're interested in the metaphysics because we're interested in the role it might play with regard to the question about the capacity to give rise to reasons. Now, it's possible that people have said, Raz has said, and I assume I have said, if Raz has said something that's false, it's reasonable for me to infer that I've said something that's false too, though not the same thing. So I'm sure there are uncharitable, I don't mean this uncharitably, there are uncharitable ways of characterizing us such that we claim that it's not the proper province of jurisprudence, but surely that's not really our view. Our view is that the metaphysics has a certain kind of priority with regard to certain kinds of jurisprudential projects that other features of law do not have, though they are tremendously significant, not just significant from a non-philosophical point of view, but significant from a philosophical point of view. In fact, just to end this on my own view, as I think I've made clear, is that as an example of an important but not necessary feature of humans that they can hear. I think I put this in a footnote at some point. If we wouldn't understand much of interest about humans if we didn't understand that they heard. We would not understand the importance of language, of communication, and so on. But it's not a necessary feature of them. The same, as Scott just pointed out to me, rationality would be true about that. So it's a little, I'm just a little puzzled as to who charitably is on the other side.
I think I agree with everything you said about metaphysics. So let me say one more time. I said it a few times during the talk, but I will say it one more time. Whether characterized in terms of metaphysics or of law or elsewhere, I have no quarrel with the importance of inquiring into the metaphysics of law. So then the question, or the dispute between us, if there is one, turns entirely on what it is to have a charitable or a non-charitable reading of what some number of people undoubtedly have said. When Raz says, quote, sociology of law provides a wealth of detailed information and analysis of the functions of law in some particular societies, legal philosophy has to be content with those few features which all legal systems necessarily possess. Raz is not someone to use his language loosely. He's not. There are similar statements in various other dimensions of his writing. Julie Dixon, similarly, in discussing Ronald Dworkin, has said he engages in particular jurisprudence. Particular jurisprudence is not the task of analytic jurisprudence as she understands it. As you observed, you not only have the footnote that you mentioned, you also have a footnote in the practice of principle about coercion, in which you say that an inquiry into coercion is simply not jurisprudence. One finds similar things in Kenneth Hima and the like. It is quite possible that you are right and I am wrong about the sociology of jurisprudential inquiry. I think if we have a disagreement, it is only a sociological disagreement about what are the norms of jurisprudence as a culture, what are the norms of jurisprudence as an academic practice. My view is that even understood charitably, the quotation that I just gave and some number of other statements are somewhat representative of a significant jurisprudential sociological trend. Your view is that these are uncharitable. These are uncharitable statements by people that I am uncharitably picking up that therefore do not represent the sociology of jurisprudential inquiry. That's an interesting methodological disagreement that goes back to the Simon Blackburn issue at the beginning. If you are right and I am wrong, then you are right in saying that there's not much that's controversial in this paper, and I would be delighted if that were the case.
Professor Alexi, here in the first row.
Thank you very much. I have a question concerning the concept of importance. you use the concept of importance, and you use the concept of statistically present, being present statistically. I think that is, my first point, that's not the same. That's not the same. For instance, it is perhaps a statistically or sociological truth that lawyers earn more money than workers. But I think that is not important for the concept of law or the nature of law. Whereas that there is coercion is important. But why? Is there a difference between the income of lawyers on the one hand and coercion on the other hand? I suppose the difference consists in the fact that law, which does not provide for coercion, is in some sense defective law. If law claims to be correct, it must provide for coercion. In any case, it is necessarily possible that law provides for coercion, whereas it is impossible for morality to provide for coercion. In this way, we have, in spite, even if it would be true, that, for instance, in international law, even in without United Nations, there was the right to self-defense, and that is empowerment to coercion. And we must look very long time to find a system of norm where there is no coercion, not even self-defense, not even self-defense. I think then we come very close to a moral system. In any case, even if there should ever have been, or will in the future be, a system of norms not even with self-defense, then we could say, and that, I think, would create a necessary, it is how much do we require in order to speak of a necessary connection of a feature with law. And I think it would suffice to say it is possible that to have coercion, and it is legal system is faulty in some respect if there is no coercion.
Thank you for that. You didn't put it in terms of 3 different questions, but let me treat it as 3 different questions. The first question is, am I working with 2 different ideas of importance? And I think the answer to that is yes, and I agree with you. That is, just as Dixon and Ross have said that we have to supplement the notion of necessity with the notion of importance, I think we have to supplement my notion of statistical importance, which is a non-evaluative sense of importance, with importance prime or importance sub 2 in your sense. And there may be things that are statistically important that might not be jurisprudentially important. In that respect, I agree with you. I'm less certain that I agree with your example. And I think this would take us too far afield to go into it in any great depth, but we might bring once again Bentham back into the discussion here. Bentham certainly would have resisted your idea that the income of lawyers is not an important feature in understanding law at its core or at its empirical, if not philosophical, essence. Bentham, after all, was the one who referred to lawyers and judges collectively as judge and company, judge and co, actually, in order to articulate his view that the very idea of judicial power, maybe even the very idea of common law judicial lawmaking, emanated out of the conspiracy between lawyers and judges to increase the income of lawyers. Bentham also was of the view, I would say that this suggestion was one he made tongue-in-cheek, but to the best that I know, Bentham's tongue was never in his cheek. Bentham also was the one who suggested once that lawyers should be, that people should be prohibited from giving legal advice for money as a way of creating the proper incentives for clear, crisp, and publicly accessible lawmaking. So without saying any more about that, once we get into important features of legal systems as we know them, I'd at least want to put, if not myself, at least Bentham up there saying, maybe your larger point is right, but I'm not sure. The example is one we might quarrel about. But I think your most important point is the question about whether law without coercion is defective or faulty as law just because of its lack of coercion. And I think on that point, although it's somewhat further afield from my talk here, I think I want to disagree with you. That is, I think I would want to perhaps reverse it and say that coercion may be what we have when either law or perhaps more accurately, human motivation or human good faith is defective. Coercion is what we have when human goodwill is faulty. It is, of course, interesting and important that human goodwill and human morality is so commonly faulty that we find all real legal systems using coercion. But if we were to discover a society so good-natured and so cooperative as a matter of morality, that it decided that it need create a legal system in order to not only coordinate their first-order norms and create first-order norms, but create the institutions for their creation of second-order norms or secondary rules. It is possible to imagine that this utopian society could exist without coercion at all. And it's not one that I would want to think of as faulty or defective, even as a legal system, just because it did not incorporate coercion. But that might be an occasion, that might be a debate for another occasion. On your first point, I think I need two ideas of importance, and on that I don't disagree at all.
En la cuarta fila, por favor, aquí.
Diana Constantinescu, postgraduate student at University College London. My comment does not wish to be an objection to your approach. It's rather either a constructive comment or, at its best, limitation, perhaps, of your approach. And if I may, I'm going to also refer to a point that you made in your paper. When you were, namely that you were referring as our concept of law as a snapshot here and now of what could otherwise be an ongoing and organic transformation of the social phenomena that is law. I was wondering if we have different snapshots of that phenomenon at different times or different space. It seems to me that it could create images or concepts of law which have unessential features but important features that could be contradictory to each other. And here you might ask, how do we decide which one is the accurate one or the fruitful one? And it seems to me that this kind of limitation does not apply to essential features because they're universal over time and space, but it does apply to non-essential and important features. Thank you.
Thank you. a nice, important, and I think valuable point. So let me, in responding to it, let me go back a little bit in sort of argumentative progression. This morning, earlier this morning, Professor Bayon referred to a view held by some number of us, including myself, that you referred to just here, the view that it may be appropriate to think of a form of normative conceptual work in which, having descriptively identified what the concept of law is, it is an appropriate theoretical task then to say, this is what it is, but here is what is wrong with it, or here is what might be better with it. And people who have some sympathy with that view, Liam Murphy, myself, Austin, Bentham, and some number of others, Waldron certainly would say that engaging in, or the ability to have a snapshot of our concept of law right now is not inconsistent with thinking that it might be better if we had a different one. Now, then you say, all well and good, but once you or Murphy or Austin or Bentham or Fuller or Waldron or any of these other people are taking off your descriptive photographer snapshot hat and putting on your normative hat, how can you know which are the appropriate normative emendations or modifications of the concept of law without having some sense of the priority among them, given that some number of the non-essential features that I have described may, as you correctly observe, possibly conflict with each other. So then, and that it is one virtue of looking for essential features, that dilemma or that problem will not arise. The uncharitable way of understanding what you have said, and I don't want to understand you uncharitably, but maybe the uncharitable way of understanding what you have said is one advantage of thinking of the priority of descriptive conceptual analysis is that it's easier. It avoids these kinds of dilemmas or problems. That's the uncharitable way. The charitable way is to say, yes, if we are seeking to analyze the non-essential features, we might at times find instances in which those non-essential features conflict with each other, and we might have to decide which of those are better or which of those have priority. And I don't deny that that might require moral work, first-order moral work, as well as jurisprudential work, or it might require jurisprudential work in more or less a coherence vein. That is, which of those are more coherent with the other dimensions of the concept of law that we have tried to analyze. Now, of course, at the next remove, there may still be a conflict, because there may be a conflict between the moral supplements to our concept of law and the desire to maintain a coherence with our existing concept of law. That That kind of conflict, which is the one that Dworkin addresses on some number of occasions, is an interesting and important one as well. But I don't want, I think the issue you raise is right, and I think the answer that I prefer is that recognizing what you have suggested means that we must engage at that point, even if not at the earlier descriptive snapshot point, at that point in first-order moral analysis. And indeed, for those of us who think very controversially, I'll say this, but for those of us who think very controversially that the 1958 Hart-Fuller debate was a debate about what the concept of law should be. It is apparent from what they wrote in that debate that both of them are engaged in first-order moral reasoning to determine, in part, which concept of law it would be better for a society to have.
Por favor, here in the first row.
Thank you. I am puzzled about your concept of important property, and I wanted to ask you whether you could spell out two very specific points. The first one is, what degree of probabilistic concentration is required for a property to be an important property of law?
Yeah.
And the second one is, how do probabilistic methods or statistic methods should work for allowing us to identify the important properties of law and to distinguish them from the non-important properties of law?
Okay, so it's a terrific question that I could spend hours answering. For the benefit of the audience, I will not. But one of the interesting things about thinking statistically in this regard is that often this form of statistical thinking requires a baseline, that is a category, and we say that something is statistically important if that something appears more often than you would suspect merely at random. So let me give an example that I've talked about in other work at some length. Think about the dangerousness of different breeds of dogs. So, for example, when I and some number of municipalities say that pit bulls, technically American Staffordshire Terriers, but that pit bulls are statistically more dangerous or statistically dangerous. What people mean by that is not that the majority of pit bulls are dangerous. They are not. What they mean by that is that knowing that a dog is a pit bull makes it more likely that the dog is dangerous than knowing just that a dog is a dog. And that therefore something can be statistically important even if it is only a percentage substantially less than 50. As long as the percentage, as long as being a pit bull increases the likelihood of dangerousness over the baseline rate or base rate, to use the statistical term, the base rate of dangerousness for all dogs, it is a statistically valuable supplement. For purposes of what I am saying here, I obviously have a stronger notion of statistical importance than that. The notion of statistical importance that I'm adopting here is one I used in the talk the word predominant. And at least for purposes of jurisprudential inquiry, I want to say that the things that might be jurisprudentially important are ones that would be predominant, substantial majority, overwhelming, some other loose term like this. I accept the distinction between the general and the particular. I accept the distinction between general and particular jurisprudence, and I accept that something that might exist in one real legal system and only one real legal system might not be of jurisprudential importance even under my somewhat more expansive notion of jurisprudential importance. So I think what I want to say is, if we identify features that are present in a substantial majority of developed legal systems, and there are two qualifications there. That is, developed legal systems rather than all, and substantial majority rather than mere statistical imbalance. If there are things that are present in a substantial majority of developed legal systems, that at the very least ought to be a trigger or impetus for serious philosophical or jurisprudential inquiry. We might, at the end of that inquiry, say, well, it turns out that there is nothing there, that there is no there in the modern vernacular. In much the same way that Scheiner and then Leiter say, if we start conceptual analysis with our common sense notions of what's law and what's a legal system, when we do the serious analysis, we may then discover that we were wrong about some things. The same thing may exist here. But at least at the beginning, I don't want to get, I think, as precise as you want me to get, given that all we are talking about is the notion of sort of what counts as good or serious jurisprudential inquiry, but I want a more robust notion of statistical importance than the ones that the statisticians might be using. And that's why I think I want to say maybe substantial majority of developed legal systems. That, for me, would be a sufficient trigger that let's start doing some philosophical work and see where it goes.
There was another Professor Shapiro.
Oh, and then there was one over. Dahlman. Yeah.
Dahlman.
Yeah, Dahlman. Yeah. And then
Professor.
And then.
Thank you.
The light impedes
The light.
So the quote that you read from Raz does seem to say exactly what you are complaining about. And it does sound extreme. But I just want to see whether he could, or just somebody could respond in the following way. They could point out that if some property is contingent, then it's necessary that it's contingent. So it's a necessary truth that sanctions are contingent, and there would be something to explain there, namely, well, if sanctions are contingent, how come we see them all over the place? And you have to say, oh, well, look, it's obviously very important for human beings, the way that they are. You see the point, how that would go. And the second thing is about precedent. So maybe Raz would just simply say, he's not doing jurisprudence, he's doing law. He's explaining a rule. He's just explaining what the rule is. The rule is that this is, that courts are permitted to distinguish precedent when the facts are the same as the other ones, but for some other consideration that allows. So it's just, just like you would do the rule against perpetuity or the parole evidence rule or something like that. It's just, he just does it really well. And so therefore it seems philosophical. Anyway.
Right.
So,
Yeah. Okay. So let me take the second first. I mean, I think this is a heroic effort to defend Raz against what Raz said, but let me take the second first. That what Raz is doing in talking about precedent, or what I am doing in talking about precedent, or what others in that vein, Grant LeMond and some number of others who work sort of philosophically in talking about precedent. So then the question is, well, it's just law. It's like the rule against perpetuities. It's just legal analysis. And then there's an interesting question about the role of generality and the role of philosophy. That is, if one is engaged in philosophical explanation of a feature that appears in a very large number of different legal systems, then if there is a distinction between philosophical explanation of that which appears in a large number of legal systems on the one hand and jurisprudence on the other, that might be too fine a distinction for me to swallow, but I can certainly understand what you're saying. To go back to the first, yes, I certainly accept that there are things that are that are contingently necessary. The features that are contingently necessary are part of the concept of our concept of law as it now exists, but we recognize that it could be otherwise. Contingent necessity, lots of people have talked about this. And if Raz is making only that claim, his language notwithstanding, I would agree with him. But when he says, which all legal systems necessarily possess, I think he's making a somewhat broader claim than that. If he misspoke, and if others in that vein have misspoke as well, to go back to Jules's comments, so much the better. Although I think that there is in my sense, sociological emanation from all of this, and that's what I want to resist.
Professor Dalmander.
I agree with you that philosophical analysis of law can be about things that are not necessary. What I don't understand is why you feel that you need to invoke the idea of importance to make that argument. Couldn't you make it much simpler? Couldn't you just say, well, philosophy is about making ideas clear? It's not about making necessary ideas clear, or making important ideas clear, or making statistically common ideas clear. It's about making ideas clear. Why couldn't you make the argument that simple?
Yeah, I think I could, but then maybe we should come back to Scott's example. So suppose, is it surprising that no one at this conference is giving a paper on using philosophy to get clear about the Nebraska rule against perpetuities? Those of us who are inspired by philosophical methods, especially those of us without philosophical training who are inspired by philosophical methods, agree with you completely that learning those philosophical methods can be very valuable, even if all we are doing is trying to understand the Nebraska rule against perpetuities. There is at some point within jurisprudence still the idea of a degree of generality. And in using importance, I want to capture a degree of generality about what pervades a lot of law that may be different from just the question, where can philosophy be useful? I'm inclined to agree with you about where can philosophy be useful almost everywhere. Is jurisprudence to be defined by everywhere that philosophy is useful? I think even I want to resist that a little bit.
Here in the second row. You must excuse me because sometimes I do not see you because of the lights.
Right.
Is this connected? Yes. I have a doubt concerning your notion of probabilistic concentration. I think you would agree that the making, as well as the assessment of any claim about the probabilistic concentration of a given feature of a given property is necessarily relative to a universe or a domain of inquiry. And the determination or the definition of that domain is, in a sense, free. You may define your domain in purely extensional terms as a collection of objects. You may define it in terms of properties. Any object displaying properties X, Y, and Z belongs to the domain. You may define it conceptually. Any object to which the concept applies, satisfied the necessary and sufficient conditions, will belong to the domain. Now, when you speak of the features appearing, is your expression on a very large number of legal systems. You seem to be taking legal systems here as your domain.
Yeah.
My question is, how do you define it? How do you define the domain relative to which claims about what is important in law?
Yeah, you're clearly right, and I think you're right not only about your analytic claims, but you're right about the domain that I am using. And again, relating to the previous question, I think that in ways that I did not talk about in the paper or even in the talk, most of us in this room understand the field of jurisprudence, the scope of jurisprudential inquiry as involving some degree of generality. So you are correct in saying that I need a domain. You are correct in saying that the domain I seem to be casually and probably too casually presupposing is the domain of legal systems. Maybe a little less casually, I'll still confess that that's the domain that I am presupposing. And I want to be somewhat capacious about that. That is, I think as we think about the features that might be important for jurisprudential analysis, it may be of some interest that some of them are located in non-state systems of rule-based social control. That is, we could argue about whether the state or municipal law or sovereignty is necessarily important for my purposes. That would be possibly question-begging and getting ahead of things. Similarly, I want to be temporally capacious. If we were to discover something that existed in most legal systems up until 1900, but not very many right now, it again to me would be, it would clear my threshold of importance. Again, a somewhat casual response, but given that we're engaged in field definition, I'm not sure that maximal precision is necessary or even desirable, but I fully take your point about domain importance and agree with your suspicion about the domain that in too few words I seem to have presupposed.
Thank you.
Back on schedule, that's fine, yeah.
Okay, okay. Thank you very much, Professor Schauer, and thank you to the audience. because of this very intense and happy session. Thank you very much.
Thank you.